Hi, welcome to Tech Law 10. This is Jonathan Armstrong from Punter, Southall Law. With me is Eric Sinrod. The astute of you may have realized that there's a third person on the call today, and we're continuing our occasional series of trying to give the brightest members of the next generation a bit of an audience on Tech Law 10. And we're going to talk about AI and its good and bad. I suspect it could easily be TechLaw 1000 on this topic, but we're going to try and limit ourselves to 10 or 15 minutes. And Eric, why don't you introduce our guest?
I will. This is Eric Sinrod at Dwayne Morris. Yes, I'm here to introduce the brains behind the operation. Her name is Jill Kawakami. I've known Jill for years now. She was a prior student of mine at a California university in several pre-law courses. She was so smart, I had to enlist her to become an assistant and actually help me teach a course devoted to helping students prepare for and be in law school. She then worked in the California court system, and she's actually currently a law student in Seattle. And Jill participates in a weekly online group that I have with former students of mine. And honestly, she's the leader. She's brilliant, and she's going to share some observations she has regarding the use and misuse of AI, first at the university level, then at the law school level. I'll respond. And then Jonathan and I, especially you, Jonathan, will bring it home into AI in legal practice. Jill, welcome.
Thank you so much for having me. Yeah, AI is a gnarly topic for sure. I got my first introduction to it back in maybe early 2020s when I was a TA at my undergrad. Had a very large class that required a lot of writing, and I noticed some discrepancies between some students in class writing and their written submitted assignments. Certain words being used, certain topics being touched, syntax, and there was pretty big discrepancy between the work performance that was happening. And that was kind of at the start of AI being utilized in the academic world en masse. Moving forward into law school, my particular law school and cohort, we don't touch a lot on utilizing AI, and that's specifically because our law school's policy is pretty prohibitive on how AI is utilized in school. There's a general ban on AI usage, of course, in exams, both closed and open exams, but it's then up to the professors listed in each syllabi how AI is utilized. And so far, every single course I've had, there's been a pretty hard ban on how AI is used. It's not allowed to be used in generation of writing. It's very limited on how you can utilize it in research. Generally speaking, only Westlaw and Lexis add-ons for AI that's built into their programs. Our law library is pretty astutely against utilizing AI. But upon that, I kind of took it to look at some other law schools' AI policies. And the most recent one that came out was University of Chicago's full prohibitive ban on use of electronics and AI for 1L law students. This was a huge deal to look at. AI is a great tool to be used, but when you're first building those skills of critical thinking and analyzation, it would behoove you to flex those muscles yourself. And so University of Chicago decided to do a hard ban on all electronics in all mandatory 1L courses, kind of pushing students to develop those skills themselves. Looking one step back would be at Berkeley's new AI policy, which is very prohibitive, but not so prohibitive to the point of disallowing electronics in classes. They have a pretty hard ban on utilizing AI for brainstorming, writing, generating, researching. So that's the next step down. And then, interestingly enough, at Eric's alma mater, Michigan, they don't have their own standalone policy. And in fact, most recently, it appears that for the law school admissions process, they've opened up as one of their 10 optional essays to be submitted as utilizing fully and completely AI to write one of the essays. So I thought that was quite interesting to see the different evolution of how law schools are adapting to this brand new tool that is becoming ever more present in our lives.
Well, thank you, Jill. Way to get us started. I'll follow up on that. I've been teaching now, in addition to my legal practice, many university law related courses. I've had hundreds of students over about the last decade and a half. And I found over the last 4 or 5 years that the essays I'm receiving have become very homogenized. They sound very much the same. The bottom has come up. You don't really see bad papers anymore. And of course, I've done my own sleuthing to find out that many of them are generated either wholly or in part by AI. So one solution I tried to come up with originally was when a student submitted an essay, they would submit supposedly their own essay plus an AI generated essay so there could be comparison on my part to divine what is what is real and what is not so much. It became a lot of work on my part. I became very tired of policing this. At the university level, we've been having many discussions about how to deal with this because you're completely correct that we want the next generation and all of us to still maintain and grow our critical thinking and cognition skills and not be wholly dependent on AI. And as I tell my students, if you're now dependent on AI, what value add do you provide when you get out in the workforce? What is your secret sauce? I've decided, starting in a few weeks when my next semester begins, to implement a protocol that I believe will completely prevent use of AI. People will have the opportunity to use AI in their lives, but in my course, you will not be able to. So rather than submit a research paper that you prepared on your own at home over the last month, you're going to come into class. I'm going to give you what's called the blue book, which has lined paper. I'm going to provide pens, and you'll have 100 minutes to write your essay. And it will be evaluated as such. I'm not going to expect it to be as stylistic as something that somebody could have created on their own at home for a month. It won't be an exam, it won't be surprise questions, but they're going to do it in class. There will be no technology permitted. And when they do presentations, rather than reading from their laptops, they will be permitted to bring in a 4 by 6 inch note card where they can put some bullet points on it so they know not to forget something important to say. And I think this might be a little bit intimidating for them in the beginning, but I will explain to them this is for their better good, and I will be kind in evaluating them because especially most of my students are going to be going on to law school like where you are now and then into a legal career, and they need to be able to think and perform. And as Jonathan, I think, is going to explain, there have been problems in the legal profession with the use of AI. And we've seen here in the States, lawyers getting in trouble by submitting papers to courts that are created by AI, citing cases and statutes that don't even exist.
Mm.
Jonathan, what say you?
Yeah, I guess I could say 1,000 things. I think the first thing to say is obviously it's a problem that's hitting the courts as well. So I just checked just as we started recording, 1809, 1809 is the number so far for tracked cases which have involved hallucinations in courts around the world. And that's according to Damien Charlaton's excellent database. I know usually that there are more cases than he has collected, despite his endeavors, and we'll post a link to that. But for me, it's obviously a problem in part with legal training and law training. Some of the lawyers who got into difficulties have been very junior lawyers. They've not had the skills to challenge the AI results that they've got. In many cases, they haven't known that the results are AI generated because they've used Google search and Gemini's taken over, or they've put an answer into a Microsoft product and Copilot's taken over. So sometimes people don't even know when they're using AI. And that's causing quite a lot of issues. Yesterday, for example, in the Court of Appeal in England and Wales, they looked at the cessation of a rape trial. It was a trial involving two people who had been domestic partners, but the one of the partners said that she had not consented to intercourse on a particular occasion, and that as a result, her partner had raped her. So why was the trial stopped? Because when she handed her phone over as part of the court proceedings, the lawyers involved were able to see that she'd been coached by an AI tool on the evidence to give. And the tool seems to have told her, say this at this point, here are the answers to questions, even gone through cross-examination with her. Now, the Court of Appeal said that the judge was wrong in saying there was no way in which there could be a fair trial, but that trial will now have to operate under really close guardrails. And I guess that's one of my concerns, that that not only is there an impact on legal training, but also on court systems and on access to justice. Giving people the wrong result more quickly doesn't give them justice. It just binds the court system. I was in Vienna at the International Data Law Forum conference 10 days ago, and under Chatham House rule, behind closed doors, a lot of regulators were talking about the problems that they're experiencing. One of them has said that they are receiving 60,000 complaints to the regulator per annum for metrics. They used to receive about 15,000 per annum. The majority of them seem to be AI generated. And not only are there, 4 times the number, but each complaint is longer. And when you knock back the complainant, they argue back with you. I know from a pro bono initiative that I'm involved with that law centers are getting the same. They have really good volunteer law students in some cases solicitors, turning up to clinics to help pro bono members of the public. And they'll give an answer to a legal problem, and then the individual gets out a stream of printouts from Gen AI and tells that volunteer that they're wrong. And in one case, then went on to a review site and told the world that this legal clinic was rubbish because it didn't get the same answer as Gen AI, and Gen AI's answer was wrong. So I think it's an endemic problem, not only for the legal profession, but also for society as a whole. More courts are seeing litigants in person who think they're lawyers just because they know how to switch on Gen AI. And that is just going to be a problem that we have to deal with. One of the things I was talking to regulators about is the need for their sites to be more visible to AI crawlers. Some have taken the view that they don't want Gen AI to crawl their sites. And that means that secondary sources that are less reliable are topping up those AI-enabled searches. So I think it is a problem that we're not going to solve in my generation. But Jill, maybe there are solutions that your generation has, and maybe literacy is the start. Maybe it's telling people at law student onwards the downsides of AI as well as the good. Could that be part of the answer?
I think so. I mean, I'm thinking back to my days coming out of high school where knowing the Microsoft Suite products made you king or queen, right? Whoever could control Excel was top dog. And that only came with understanding how the program worked, understanding its functions, its limitations, understanding how to manipulate it, and understanding when you were stuck, where you could go to ask questions. I think right now we're stuck in a bit of a feedback loop when it comes to AI of when we're unsure of what to do with AI, we may ask AI and get a biased answer. We also may get one, as you were talking about, that isn't fully fleshed out. We may get one that is not utilizing the best resources that we could to help us enable that critical thinking about a problem that we need to solve.
What about judicial clerking? I mean, that's traditionally been the route, I think, hasn't it, for a lot of lawyers in the US? Am I wrong to, the brightest and the best have come through judicial clerking positions? Is the training there around things like AI issues?
Well, I don't know if that's currently the case. Maybe Jill, you can comment on that. But I clerked for a federal judge, but it was back in the prehistoric days when dinosaurs walked the earth. Earth, you remember, Jonathan. And there wasn't training at all. We just came out of law school. We were considered fully baked, and off we went. And we were researching and writing judicial opinions for the judges. Jill, based on your recent experience a couple of years ago in the California court system, do you know whether um, clerks working for judges actually had any sort of training in terms of best uses or not use of AI?
From my very limited anecdotal experience with the court that I worked at, it was a much smaller court. There was no clerk that was utilizing any generative AI. The local rules had recently been updated to include a local rule policy written by the judicial officers on litigants coming in and utilizing AI in the court. Um, and anecdotally, from a few of my cohort students who have done extern judicial clerkships, it's kind of been the same as you experienced, Eric, in the past, where you come in kind of fresh-faced and you learn from the judges themselves on how to write, how to edit, um, the best ethical practices and moral practices. At the career level of a judicial clerk, I'm not entirely sure. I did recently have a friend who is applying for a judicial clerkship, and he has to go in and do a timed writing sample on site with no technology available. So that may speak a little bit to judges being a bit concerned or a bit hesitant on utilization of generative AI.
Yeah, I have to say,
Yeah.
Jonathan and Jill, I'm sorry, I'm a little bit worried and cynical just based on what I'm seeing, uh, because my students are required to do presentations in my courses, and they're about to go to law school. And I tell them, you're not supposed to use your technology when you give your presentation. You should know your topic. And they just can't help themselves but open their laptops and look at them. And I don't want to embarrass them in front of the class. And I read some articles that talk about how the majority of students will, when they're surveyed, will say they use AI in whole or to a great extent in creating their written work. And so these are the people then going to law school and becoming lawyers. You were going to say something, Jonathan.
Yeah, well, all I was going to do, I think that's a really, really good point. But I wanted to pick up something that Jill said that I thought was really interesting as well. And I love the quote about, whoever could master Microsoft would be the king or queen. That's certainly whenever I've been trying to set teams up for investigations, for example, I've always valued somebody who's really good at the technology, who knows the numbers, and can sweat the system. And we've developed a number of technology things to do stuff where we've got somebody on our team who's really good at that. So shout out James. But one of the things that I think we ought to say for balance almost is that there is absolutely still the role for that king or queen in a law firm environment. And there are AI technologies, for example, those based on technology assisted review, so TAR tools. The recent refresh of the UK judicial guidance on AI has said that they've been used for many years with seemingly no problems. And when we wrote the New York State Bar Association paper on AI and its impact on the legal profession, we ended up with saying that the role of a lawyer would be either to understand AI or to phone a friend who did, or to disclose their lack of knowledge of to the client. And the reason for that is that in some cases, let's say an investigation, let's say responding to a subject access request, AI can probably do it better, cheaper, quicker than a human. So we can't throw the baby out with the bathwater. I think we can't say that the future of the legal profession is AI free, which again, I think gets back to how lawyers are trained, because you can't ban AI in the law firm environment. It just becomes shadow AI. Associates of law firms just pick their AI engine of choice and type the answers in themselves. And we've had a really unfortunate case with some insolvency proceedings where a very junior lawyer decided to argue with the judge because she thought that AI knew better than a really experienced judge did. Now, dear listeners, predict which way that went, but let's just say there are disciplinary referrals for that lawyer, for her immediate supervisor, and for the partner who ran the team. And obviously, you know, as always with these cases, I think career limiting for the junior lawyer involved. And whilst they shouldn't, do stuff like argue with judges, uh, part of that, I think, is a default in the way in which they've been trained. And Eric, I know we've said we're dinosaurs, but it was, I trained with a partner who would slam a ruler on the desk if you got things wrong. And I'm not suggesting that as an environment in which junior lawyers learn, but you didn't make the same mistake twice if the ruler had been down. um, and that is the wrong way. But we need more hands-on training, I think, for junior lawyers particularly, if the training, pre-firm isn't going to be good enough to set those basic rules of professional competence and AI literacy.
Yeah, that's a good point, Jonathan. And obviously, it's not like we're going to be AI free in the legal world. And I guess I'll throw it back to you or both of you with a question. In the law firm environment, do you think it's up to each law firm to decide how to guide and train and instruct lawyers to use and not use AI within that law firm, or there should be some uniform rules that cut across all law firms in terms of do's and don'ts?
I'll start us off with that. I am personally of the belief that there should be uniform guidance. We have many documents and that have built our legal system, many doctrines, statutes that cohesively apply to everyone uniformly. And I think with something as tenuous as AI, as big as AI, that there should at least be a baseline for newer introductions to the legal field to have some sort of starting ground. And then that's the floor. Build up from there. At minimum, we need to have a floor. And then if a law firm would like to go to the ceiling, let them shoot for the stars.
Yeah, I think that's absolutely the right answer. I mean, for full disclosure, I'm still on the New York AI and Emerging Technology Law Committee. We're trying to produce some revised guidance from firms, but firms have to adopt it and they have to train their lawyers in it. And I think the difficulty of not having some sort of core guidance is that it then becomes difficult. I know that a lot of people are saying with litigation, for example, in the US, so many different judges are making their own court rules that it's very difficult if you're somebody who practices, between 18 different courts to learn that specific judge's rules each time. So I think in some respects we're in a luxurious position in that in England and Wales, the courts tend to have uniform judicial guidance. Some of the tribunals have added to that guidance or adapted it because of the number of hallucinations from litigants in person, particularly. And another initiative that I'm involved with is trying to give guidance to litigants in person as well. Lawyers aren't the whole cause of the problems here. Often litigants in person are taking up a lot of court time using Gen AI, perhaps more than lawyers are. In Australia, I believe that a lot of the courts there now give litigants in person a booklet when they issue proceedings to say these are your responsibilities to ensure that your documents don't include Gen AI hallucination. And I think that's a really interesting model, and other courts might want to adopt that as well to reduce the chances of court time being misused by people producing nonsense in court.
Well, good points. We're probably past our 10 of Tech Law 10. I hope we all feel complete. First of all, Jonathan, it's always great to see you, as I do every month. Jill, I get to see you every week. Jill, thank you for joining us. It was wonderful to have you as a
Yeah,
guest.
fabulous.
I think this is video podcast number 301. You acquitted yourself well. Jonathan, Jill, do you have final comments?
No, just thank you so much for having me on. It's been a pleasure.
Our pleasure to have you, Jill, as well. And I look forward to you coming back on when you've solved all the world's problems, maybe in 6 or 7 weeks' time. But thanks very much for bringing an interesting topic to us. It's been a really good discussion. And thank you to everyone who's watched and or listened. There'll be some notes on the YouTube version of the film, which will expand on some of the topics that we've talked about and some of the cases we've talked about. The judicial guidance link will be there. All that remains is to thank you all for watching or listening.
Cheers. Thank you.